I want to talk about the trial. You've tried a lot of cases. You came up, I know your background well, you came up suing Big Tobacco for putting poison into the world and killing people. And you've tried a lot of those cases. You've represented people in all different types of cases. You've told me privately, and I'll share this with the world, that this was the most impactful case, I believe, in your career in a lot of ways. And I'd like you to just talk about how this case, how the trial went and how it impacted you.
Well, the one thing that when you have a patient who is catastrophically injured like this, you do feel a great responsibility to that patient to get them justice. And I certainly felt that burden when you're trying the case. It puts a lot of pressure on you as a lawyer. I probably have maybe half of my clients are wrongful death cases where the patient is deceased, and that's has its own pressures, but there isn't the same need that there is when you have a patient who has real needs. And so that was one of the pressures. This case was extremely complicated, and just on a daily basis, it really was challenging intellectually for me, for the rest of my team, to understand the medicine and to then present the case in a way in which a layperson could understand. Literally with 50 depositions, I have read, hundreds of articles about stroke and stroke care, and there was a lot of complexity about how this stroke, if it had been diagnosed, would have been treated and what were the outcomes, because this was a bad stroke, right? There's a lot of different kinds of strokes, and this is probably the worst. And one of the defenses that the defendants put up was this was such a bad stroke that no intervention would have made a difference. So even if our doctors had done the right thing. So the difficulty from a lawyer's perspective was I had to, and you had to, and other people on our team had to understand all of this and then present it simply. How do I present this in a simple way? And I'm going to invite you to talk about what some of the visual aids were, because those were your inventions and your suggestions as to how to explain, the treatment for stroke in a way juries could understand.
Well, these when you look at the medical language, and you as a lawyer, you can get pulled into the terminology and get kind of proud of yourself for understanding it and being able to speak the same language as doctors when you're talking about, basilar artery occlusions and thrombectomies and all these sort of fancy sounding words. But our job as lawyers, as you know, is to simplify things and make it accessible to the jury so that they feel like they're in a position to judge the behavior. And if it's spooky and scary and inaccessible, then it makes it hard to do that. So stroke cases kind of lend themselves to some very simple analogies. And the one I like and advocated for, and I think connected with a lot of the jurors, was that analogy of a plumber, and that a stroke is like a clog in your pipe in your bathroom. And when there's a clog in the pipe in your bathroom and the water's still running because you can't turn the water off, really bad things are going to happen the longer that clot stays in place. You're going to flood your kitchen or flood your bathroom and your house and all those kinds of things. So it's real important to get that clog out as quickly as possible. Juries can get that. Well, how do you do that? Well, in your house, there are two ways. You've got liquid plumber, which is the equivalent of what's called TPA clot buster in medicine, and that dissolves the clot. That's one option. And then the second option is you can use a plumber's snake to go down there and pull this clot out. So the two interventions, the two things that are available to pull a clot out, like what Jonathan had, is the chemical TPA clot buster, liquid Drano, or what's called a thrombectomy. It's a big tool, or a little tool actually, that they weave up through the arteries up into the brain. They pull this little clot out. Well, we brought in a bottle of liquid Drano. We brought in a little plumber's snake about a foot and a half long with a little claw that comes out when you push the button on it. And I think using those kinds of examples really helps the jury demystify the medicine and say, look, there's a clot. You should have seen it. It was in the imaging study. that clot stays there, he's going to die or be horribly bad off. Now, fortunately, we had I believe, the world's leading expert in thrombectomy participate in this trial. And Laura, would you talk about the Dr. Raul Nogueira, who is former head of the stroke unit at Grady Hospital here in Atlanta, and the role he played at trial?
Yeah, let me first speak a little bit to the other lawyers who are listening to this. You, as a lawyer and as a juror, you try and find that balance between a witness who is an expert, who is well credentialed in their field, but an expert that also is in the trenches, somebody who's actually doing this work. As opposed to somebody who's doing the writing and doing the researching and really is more of an academic. So when we were actually nearing trial, and the leading expert, I believe, in the world on basilar artery occlusions, these kinds of stroke, and the right treatment for them is this physician, Raul Nogueira, who was at Grady at the time. I had been trying for years to get him to even return my phone calls. When you came on board, you had his cell number because you had a previous case with him. And when you got in touch with him, he was very willing to step in and give us causation testimony, which we needed to sort of firm up some of the causation. He had he was the triple threat. One, he did the academic stuff. He had written, I think he testified 400 articles in the medical literature.
Wow.
He did this. He clinically treats these kinds of patients. So he had both of those. But the third was, he was the one who, if our patient, if Mr. Buckelew had been diagnosed, it would likely have been Dr. Nogueira who would have done the procedure on him. So he was an extremely important witness for us, did a great job of really letting the jury know that John's life could have been different had the appropriate interventions been undertaken in a timely manner.
And I would say he was a four-way threat as well, because he's a natural teacher.
Yes.
And he was off the stand. He was able to help the jury understand the medicine, but also the data, because one of the key points in key disputes was, would it have made a difference? And you touched on this earlier. Would intervention, would pulling this clot out earlier have made a difference? And Dr. Nogueira has been the pioneer in so much of the literature and the research, and there's very current research that shows this would have made a significant difference in this particular patient. So all those pieces came together. But of course, the bottom line with Dr. Nogueira is he believed in the justice of the case, and
he was a very, very passionate witness. I think, which was very helpful to us, and just so that the people understand, this kind of stroke 20 years ago, they wouldn't have. There weren't treatments for it, and it was really because of Dr. Nogueira's pioneering work that physicians have started to treat these kinds of stroke with really good outcomes if they're treated in a timely manner. Of course, we had such a poor outcome because essentially Mr. Buckelew didn't get any treatment at all.
When you think back on this trial, Laura, what are the parts of the actual trial that will stick with you forever? The pieces that are sort of fused in your memory or your experience that you'll carry with you for the rest of your.
Well, one thing I think we had to our advantage was we had the team basically at counsel table. It was you and I, and on the other side of the courtroom there were, I guess, 12 lawyers,
an army of defense lawyers, where
they had extra tables set up. Some of them were behind. There were 2 rows of them at some point, and we really had a lot thrown at us because of that. And as a lawyer, it really does call upon your best self to be able to take keep the focus where it needs to be and keep going despite being, getting multiple, motions thrown at you and the evidentiary issues thrown at you. And you're trying to tell a story, right? So you have to be a storyteller and also a lawyer. and a storyteller and also a lawyer. And so that's a really difficult thing. And in this complexity of this case, that was a difficult thing. But the moments, I think we could all agree, was when John came in and testified.
Tell us about that. Set the stage for that and tell us how that came out.
So what we decided to do was at the end of our case, after we'd put on all the medical evidence, after we'd put on all of the, the number evidence, how much it cost to take care of him, all of the causation testimony, we then brought him in as our last witness. And he's only able to speak by you have to say out all of the letters, and then he lifts his eyes up when you reach the letter that he wants to spell out the word for. So you A-E-I-O-U, and he lifts his eyes up, and then you go A, E, and then he lifts his eyes up for each letter and spell it out. So what we did was we set him in front of the jury, and then we asked him some yes/no questions, and Lloyd actually took this piece of the trial. Asked him some yes or no questions, and he was able, how, you feeling good today? Up for down, up for yes, down for no. And just, do you know where you are? Up for yes. And then he would spell out words. And it was really a beautiful moment because his mother was doing the listing out of the letters, and we were spelling the words out on the board, and the jury was just really, really, dialed in and focused on it. And it really did, I guess, highlight the importance of the case. Was we're not talking about a name on a medical record. We're not talking about, this picture of a person, but this is a human being who this negligence of the doctors permanently impacted their life. And so that was one moment. But then also the podcast moment, of course, was and I'll let you talk about that moment.
As the resident podcaster, that was a special moment for me as well. So just sort of to set the stage. So this was one of the issues in the case was that the emergency room doctor had gone back in and changed his medical record after he learned the following day that Jonathan had experienced this terrible stroke. So the ER doctor had been on the shift and responsible for Jonathan, and he documented in his notes what his treatment was that day. The following day, the ER doctor came back on shift and learned that there had been this terrible outcome, and the ER doctor went back into his notes, and he altered his note. He put in additional information reflecting this conversation he had with Dr. Futrell, very self-serving, the neurology consult, but very self-serving, in our view, information to sort of protect himself. Well, we didn't know this until long after the lawsuit was filed, but you, Laura, did an excellent job of getting the audit trail data, getting the information that revealed this change. So we get to trial. ER doctor's being questioned by his attorney, and the ER doctor tells how he had changed the record, but it was perfectly fine. Well, then they bring in an ER expert to give his testimony and say, oh, it's fine for ER doctors to change their notes after they learn of the outcome. It's perfectly fine because you want the note to be accurate. As long as it's accurate, it's even adding information, that's perfectly fine. Well, we had done our research, and we learned that this particular medical expert had done a podcast, and he did a podcast on medical legal issues, and we had listened to the podcast, and I had a clip of his podcast, and I said, well, doctor, you're saying to this jury that it's perfectly fine to change your record. And he says, yeah, that's fine. It's accuracy. It's important. Even after you know the outcome, all that's fine. And I said, well, let me play you a part of your podcast. Well, the defense jumped up and down, and the judge sent the jury out. We had a big argument about it, but the judge allowed me to proceed. So the jury comes back. And I said, well, doctor, let me play this part of your podcast. And we play this part, and it's a piece of his podcast, and he says about another case, the medical expert says, well, let me tell you about this case. You're not going to believe what happened. The physician learned about the bad outcome, learned about this stroke, and went back into his record, changed his record, added new information. You can never do that. You can absolutely not do that. And if you do it, it's the death blow to your defense. So he had basically given in his podcast, advocated the exact opposite position he was telling the jury under oath. And it landed like a bomb, and the jury...
And the jury visibly reacted.
Yeah, what was the jury's
always
reaction?
fun as a-
Yeah, the jury. I mean, the jury, and this is the beauty of a trial, is to reveal, the truth. And the truth was this doctor came across like a paid, hired witness, willing to say anything, even if it contradicted his podcast that he had given shortly before.
And
so
the
that's a moment
takeaway,
I'll remember.
the takeaway too, Lloyd, is that even though that case we had researched and worked and whatever, you've got to remember that podcast came out 3 months before trial.
Right.
So you have to redo some of that research. You can't just rely on the research that you did on the witness a year ago, because there's more out there. And it was your, I think, persistence and really, well, let me see if there's anything new that he has put out. And it was a really important moment in the trial.
Well, I'll remember that for a long time. And for any lawyers that are listening to this, I would recommend and urge that Sherlock Holmes instinct. Just keep digging. There's so much stuff out there. People love podcasting. I love podcasting. I enjoy this. But so do experts. So do witnesses. So do defendants. So that's one avenue. But be diligent. Look under every stone. And it's it's important for the case, and it can really turn the case. Any other moments that stand out for you, Laura?
I think any time that the defendants are doing something that is, so they brought in a witness to say that John, who had already lived 7 years from the event, because the event was in 2015, and they brought in a witness who said John was only going to live 9 more years. He was basically a statistician. And I had, because, trial lawyers share information, I had gotten some very good information about some inconsistent things and some really damaging things that he had said in the past from other transcripts, from other cases, from articles that he had written. And as I start to, he's on the stand, and as I start to ask him questions, I can see him begin to shake.
I remember that well.
Shaking. And as a
you
trial
have that effect
lawyer,
on people, Laura, sometimes.
As a trial
especially people
lawyer,
on the stand.
it's a fun moment when you're cross-examining and the witness is trembling in fear. And I think he really, really lost all credibility in front of the jury. And that was an important point, because we needed the jury to understand that they needed to give enough money to help John through the rest of his life, not for 9 years, but what we said it would be, which would be 33 more years.
Well, and the corruption of that argument it was just palpable. I mean, the idea of bringing somebody in to tell the jury, give him less money because he will probably be dead from the thing we caused.
Right.
I mean, he's in this condition because of our negligence, but being in this condition, he's probably not going to live as long, is the argument. So reduce the amount of money he has to take care of himself for his lifetime. It's a really ugly argument. I don't think the jury obviously they were not impressed by it at all. They're probably repulsed by it.
And another nice thing that this case had is that because there were so many defendants that were at odds, there were times when you and I could sit back and let the defendants, start poking at each other. That's uncommon in the medical malpractice world, but it was so fun to watch. Because these, and it's all, I say these men, they all are men usually, but these men are our adversaries all the time, and to see them going at each other was very fun.
Well, one aspect of this trial that I'm going to remember for a long time, I'm going to brag on you for a second, is how resilient you were when you were receiving a lot of little barbs and not so subtle attacks, basically because you're a woman. And I saw it, and they didn't come at me the same way, maybe different barbs, but nothing like you endured. And I saw you for 3 weeks put up with this almost on a daily basis, these little sexist comments and mockery and those types of things. And I was impressed that you had the resilience and the poise to deal with some of that, because that's just one more layer of aggravation and distraction that could pull you away from the story that needs to be told. So I was very impressed.
It is a challenge as a lawyer to not let yourself get drawn down in the fights with opposing counsel, because they're doing it on purpose. They're doing it to take your focus off of the jury, which and Lloyd would occasionally during the course of the trial send me notes that say, chill. Chill.
That's true. A little one word advice: chill, relax.
Because the story is being told to the jury, and the defense tactics, and that's a lesson that I think young lawyers need to learn, is that you have one audience, the jury, and that's who the story is about. This is what this case is for, and the people over to your right are going to try and take you off message.
Well, and to your point about younger lawyers who might be listening, when I was a younger lawyer, you feel like you need to respond when you're attacked. This is very human nature, and it feels horrible when you're in court, particularly the more experienced lawyer who's kind of making you feel bad or feel lesser, like you don't know something or you're not doing your job correctly, and you feel defensive. And it's real easy to lash out and be sarcastic or aggressive. And that is an exact wrong thing to do in court, because you're right. The jury is the audience. And when they see the lawyer squabbling, they don't pick sides and be like, well, that plaintiff's lawyer, is really getting mistreated. They just think you're both jerks and unprofessional and full of yourselves with ego. So it's real important to figure out how to just put that aside and stay focused on the story of the case, the client, and of course the jury. One last area I want to talk about, and then we'll conclude. But I want to talk about when the jury came out and announced their verdict, and then chose to stick around and talk to us afterwards. Tell us about that experience from your viewpoint.
Yeah. So when you're picking a jury or selecting a jury and going through voir dire, and you just see all of these people that you're plucking out of their lives, and many of them raising their hands saying, I've got this going on in my life. I've got this going on in my life. And it's 3 weeks of their time. You have a tendency as a lawyer to think, wow, I'm asking a lot of them and I don't know how engaged they're going to be. But this jury, they came every day on time, and it was 3 weeks. And when they were done with their job, instead of like rushing back to their lives, they stayed around to talk about it. And I think it's important. Well, one, it's important that you respect their time when you're putting on your case, that you put your case on honestly, because they, don't lie to the jury. Admit when you've got something that hurts you, and be honest. And when we went back to the jury, they were so engaged in what they had learned, and were really complimentary of our team, and were really concerned about doing justice, and doing the right thing, and they told us they had made timelines back in the jury room, and that was it was an impressive moment to see how engaged these 12 people are, random strangers that are thrown in here and asked to do such an important job for our civil justice system. And I really encourage every person I meet, when you're called for jury duty, when you're called for jury service, go with a heart that says, what I'm doing is important. It's not drudgery. It's important. And it's an honor to be able to serve your country or your community, your state in that way.
You're preaching to the choir on this topic, and I could not agree with you more. The only thing I would add to it is that the experience of jury duty seems to impact the jurors as much as it does the clients and the lawyers. And we had a chance to talk with this particular jury for several hours after they rendered their verdict. and they were willing to talk. Of course, it's voluntary, and the defense was there too, and they had a chance. Some of the defense lawyers spoke to him as well. But what impressed me was how much they cared, but how much they had formed a group. And they had they told me they were exchanging emails and cell phone numbers. They had plans to get together after the jury and sort of little mini reunions. But it kind of sort of ignites or quenches your thirst for belief in the human condition. I mean, people care, and they have no interest in the outcome of this verdict. They're not getting any of the money. They're not going to be responsible for anything after their service is over. But hearing the story of a neighbor, of a citizen who had experienced an injustice, they cared, and that was they told me that this is something that they're going to believe and remember for many years. And the one last point I make on that is there was a gentleman who was born in India. His language, English, was a second language, and there was some challenges understanding him because of his accent. He hadn't been here for many years. And there was some reluctance. I'll just admit it. There was some reluctance on our part, seating him on the seating him on the jury because we didn't know, if he'd be the best juror for this kind of case. And after the jury came back, he walked over to me and he said, "Thank you." He goes, "Thank you for allowing me to serve on this jury." He goes, "I learned more about this country over the past 3 weeks than I have in the years that I've been here." And that was just a beautiful moment I'm always going to hold on to and cherish. So
it's a heavy responsibility that lawyers have when we try a case in front of a jury like that, and I take that responsibility seriously. I know you do as well, and it's just nice when you get a juror who you have the opportunity, because oftentimes you don't get the chance to talk to jurors afterwards. In Florida, you're not allowed to, but it's nice for that little reminder.
Well, the fight's not over. The verdict's been rendered, but there's some post-verdict activities that will take place before the case reaches a final conclusion. We are not at liberty to talk about all those things, but can you give us a sort of a broad view of what the future holds for Jonathan and his family?
Yeah, so we've got, obviously we're going to be in the process of, the first thing is that we've asked for interest to be added, prejudgment interest, because we made a demand a long time ago that they didn't pay. And so we're going to have a hearing on whether we get interest in addition. And then we're going to start if the appeal process, they might file appeals to what has happened, and then we'll start the collection process as well. And it's not over, but this is step one, which was a victory, and you and I get to keep working together.
Well, that is going to be a pleasure, and I've enjoyed working with you, Laura. It's been such an honor to have to work with you on this case and to have you on this podcast, and I look forward to working on this case and getting a final resolution for these wonderful people. So thank you for being here today.
I've enjoyed the conversation, Lloyd. Thank you for inviting me.
Absolutely. Well, I'm sure we'll have an opportunity to have you back on in the future. So thank you very much. And thank all of y'all for listening today on Face the Jury.